And when I want things from her, she is very willing to give them to me, but not for free. What have you got to give me, Annabelle? What story can you tell me? And then I will give everything that I have to you. She has a doctorate in law. She also has a master in communication and a doctorate in communication. So you can't add up her titles. They're longer than her name. In addition to being sought after internationally as a lawyer, she writes in the most sought after professional journals in communication, and she wins national awards. And yet, whenever we need her, she is there for us. Dr. Sunwolf.
So, drawing upon your intense and varied legal knowledge, basic question. What percentage of the trial is a jury legally obligated to listen to? Put the answer in your head. What percentage of a trial is a juror supposed to listen to? Answer? Now, ask yourself this, my rebels. What if they don't? I was an appellate lawyer for 3 years, a trial attorney for almost 20, and I can tell you there's nothing like messing with the system a little bit by drawing their attention to their own rules and saying you're not playing by them. Do you think your jurors have listened to 100% of your trials? Did you ever ask for anything for that? Did you ever make it work so that you're going to win no matter what? That's the kind of stuff we're going to play with today. So remind me to get to that and what we get to do with jurors who don't listen and how that can get you a juror excused for any reason. We're going to do jurors deliberating under the influence. We're going to do jurors and religion, and what happens when Jesus is in the jury room. And Jesus is in the jury room more often than you may have suspected. We're going to talk about wonderful forms of question drawn from all kinds of places, new ways to talk to jurors that gives you wonderful answers. I'm going to pass out some of my brand new forms that will change the way we do questionnaires. Yes, there's 1,000 pieces of law. I was an appellate attorney. I want authority for everything. And later in the week, and as I'm working with you, I'll be sure to give you all that, or in the cave. But I want to get you as much stuff for talking differently to jurors with different results and better things, challenging more jurors, because does anybody here currently get enough peremptories? Here's why I always loved Voir. Cup tip. Now, they haven't heard any evidence. I'm having fun. And then opening statements happen, and the jurors are looking at me like, you seem so nice, hon. You didn't tell us about that. So I like Voir. It's a wonderful thing. My doctorate was spent studying real jurors deliberating, and I'm going to share some of the wonderful stuff about that, but mostly we're going to have 1,000 questions for every bad answer a juror could give you, every bad situation, every dilemma you face on everything from DUI to death penalty. But first, a word from our sponsors. Great moments in Anglo-Saxon jury history. It's fascinating to let jurors even know where this came from. The original way we determined guilt and innocence in the Western world was trial by dunking, and it worked for centuries. So we aren't all that modern. Then they came up with, by the 1200s, 12 compergators. And they said, each of you gets to pick 12 friends. You can't have strangers because they won't know you. That sounds crazy. They would think our system is nuts to have 12 people that don't know you. Because how are they going to know if you're lying or not? So it used to be friends that got to do it. Then we get these strange things I started investigating. You know, as an appellate lawyer and a survivor of way too many trials, I start looking at the history. Jurors think the system is fair. We talk as if we're lecturing them about a fair system, and it isn't. In 1966, that wasn't that long ago, jurisdictional, there were still 3 states that prohibited women from serving on juries. Somebody want to take a stab at one of them?
Georgia.
No, Georgia?
Louisiana.
Always ask Mississippi when you're wondering about an antiquated state. South Carolina, of course. serve as a juror if you were a woman. I like telling jurors that. You know, didn't mean you weren't a defendant as a woman. And then when they finally changed it, they said, well, you can serve, but you're going to have to come down and sign up and say you want to do it. So it's not a good system. It's still not a good system. 1993, a whole group of jurors on a major case, and this happened to you just don't know it, decided that some of them, being bilingual, would deliberate in Spanish. The others deliberated in English. We didn't think to ask them about that. Just because you got bilingual jurors, you think you're going to keep people from talking a language they're more familiar in, not unless you raise the issue and make it work on your client's behalf. Oh my God. 1995, murder trials. 1995, this isn't the 40s. Murder trial. Jurors are deliberating. They can't decide if the guy is guilty or innocent. Most of us call that reasonable doubt, but according to the jurors, that didn't necessarily mean that. So one of the jurors the next day brought in a Ouija board. As they tell it, they put their little fingers on the planton, and they said, who killed you? To the defendant, now deceased. And sure enough, it passed over the defendant's name and then talked about the motive and the weapon used. And then they convicted him. This we find out much later. In 2001, murder trial. Jurors couldn't decide between first degree and manslaughter. Again, you'd think reasonable doubt instruction would give us a little help here, but apparently not. One of our brothers or sisters didn't explain it well, so not wishing to ruin everything, they flipped a coin. 3 months later, after the conviction was entered, first degree murder, it leaked out because people talk. And when the foreperson was brought in to say, why'd you flip a coin when you knew it had to be unanimous? He said, because we unanimously agreed to flip the coin. So I've become a specialist in juror misconduct. And what I can tell you now is reviewing every juror misconduct case there is. It only happens in 2 primary times. One when the jurors are together, 2 when they're not. Got a little cartoon up there real quick. We, the jury, find the defendant guilty and ask that we no longer be considered his peers. I'll take this one. We find the defendant not guilty, but not all that innocent either. That's fine! However, here's the problem we've got. I'm going to read you through it to give you a quick thing, but you can tell. At the top is a very nice box. This is the evidence on something that you presented. The splat down here is what they received. What is every sentence, every fact you present to them through cross or direct? How is it getting distorted? Their mood, their culture, their education, their expectations, their hopes, their schemas, their myths, TV shows they watch, their gender, their religion, everything is distorting it. So what does Voir do? Gives us our one and only chance to find out about those things that are going to distort it and do something about that. So the first thing we're going to do is take a look at the juror's world. How do they come into court?
Thank you for coming. Now, I realize that you were summoned to this class without signing up for it. And you haven't even been told what this class is about. Nevertheless, let me tell you what the rules and procedures are. This course could take a few days or a few weeks. I'm not sure. This course could be taught by 10 or 20 different teachers, and it will involve a subject you know nothing about. In fact, if you knew something about the subject to be taught, you couldn't take the class. Each teacher will give you relevant information about the subject, information you'll need for the final exam. However, I will not tell you what is important and what isn't. Not only must you determine what is consequential or not, you must also figure out which teachers have told you the truth. And you can take notes to remind yourself of what you've heard or what you thought was important. Also, you may not ask your teachers any questions, no matter how confusing the lectures are. Nor are you allowed to talk to your fellow students about anything the teachers have said, even though this is normally how you go through a college course, or life for that matter. And while it might be helpful to have a notebook for notes, course materials, or even an idea of what the final exam might be about, it ain't gonna happen. However, we will let you look at some of the materials while one of the teachers is lecturing on other important aspects of the course. Now, I won't be telling you what is important in this course, or what the rules are for the final exam, until all the teachers have given their lectures. When I do explain the final exam, I'll spend only 15 or 20 minutes on it. And I will probably use unfamiliar or technical terms that I will not explain. The final will involve only 1 or 2 questions. And you will have 1 sheet of paper to write the answer on. You can then discuss the course with each other, but bear in mind, you will all have to agree on the same answer to receive credit for the course. You will also be locked in this room until you reach agreement. Oh, and one more thing. Depending on your answer, someone you don't even know will either win or lose. Any questions? Good. Let's begin. This will be a rewarding experience for all of us.
The contamination of the jurors happens way before you go in. I'm going to get to voir dire real quickly, but I want you to be aware that the orientation the court gives, the films the court shows people, the materials they pass out have contaminated the people before they even hit your courtroom. And so you have a right to know it. Right now, the American Judicature Society puts these out for free to all courts, so they all have them. You can get hundreds of them. I'm sure your jury commissioner has them. I wrote away for them for a law school course I now teach on juries in the law. They are full of things that are illegal for a criminal case because they have merged criminal and civil. And they've got this little booklet with them, and you haven't even read it. How cool is this? By the way, a challenge to jurors who've been exposed to information that has now contaminated them is called a challenge to the veneer, because your trial hasn't started yet. And just make it hard for it to go through. So I'm going to send these around. Anybody who wants to can keep them. I got 3 extra copies. Just grab it and hold on to it as the selfish people you are. However, the big one that I want you to order is called Behind Closed Doors. Also put out by the American Judicature Society. How do you find it? AJS.org. It gives you all the recent law on jurors, all the current practices, the best practices. It's highly persuasive with who judges. If it comes from this booklet, judges know this is what they should be doing. So I'm going to kind of give you this and a lot of other websites that will really turn you on to some stuff that we should be doing behind closed doors. It's a resource manual to improve the jury system, but it's got really cool things to ask for on it. Let me begin with the concept that I believe most of your jurors, when I was trying cases, anybody ever pick up somebody else's caseload? You got transferred into an office and, yeah, okay. Anybody ever transfer to another case? You know what happens at the end. When you know you're transferring off the caseload, you start continuing over all the cases. You're not going to try. So when we take this new caseload, we're going, oh, this is the worst of the worst. And so voir dire becomes really important because you know you're going to have really bad cases. I believe that every juror who enters your courtroom, or 90% of them, are incompetent or impaired or disqualifiable. And that doesn't even count prejudice or bias. Some of you may have experienced that no matter how good we are, it's very difficult to get a person to say, I am biased. It does not help to say, would you please raise your hand if you're prejudiced and biased. You see those hands. I raise my own. But they are incompetent and prejudiced. Let me tell you the thing that is the first, and I'll share with you all of the research on it. I study now at the intersection of bioneurology and human behavior. So what I look at is cognitively what's going on in people's brains. What is the capacity of a person to remember something, to store it, to have it disremembered? What does a belief system look like up here? And then how does it affect our decision making, our choices, our social perceptions of other people? In the first book I wrote, and feel free to, I'll point out all the cool sections and you can just copy them down to your heart's content. We took a look at stress and its effect on jurors. Every study that has been done on how stress impairs us all is listed in here with a description. So I don't just cite the study, I tell you the exact facts. You can just read it on the record. Here's what happens when people have this. And what does stress do at that level? Distracts you, totally impairs short-term memory. Is that kind of important for a juror's job? Yeah. So now instead of, are things kind of busy for you, ma'am, in your life? Is this like really a bad time? You can go, I know, are you feeling some stress? I also have all the statistics from mental health and the websites that show it, that show now there's more than 60% of workers who are impaired by distracting stress in their own lives. So the chances are they're sitting out here too, and that's building a really good record. So I'll keep harping on that. Jurors are stressed. What does that say for voir dire? We voir dire on stress. Ideally, I put it on a questionnaire first, which is, please list all of the things in your life that are currently causing you some distress or some distractions. Then I will deal with that on case by case. But if I'm voir diring live, which is the skill we're going to be working on tomorrow, I would say the same thing if that's all I got. What are some of the things that are distracting? Starting out with the panel, I want you to each think for a little bit. We all have different degrees of stress and distracting. But stress when we have family, health, finances, and issues at work can be painful and distracting. I'm going to ask you which of those are current in your life now, because no court has the right to ask you to increase stress in your life that impairs your health. And we can't ask you to have that. We can ask you to look forward, not too much money, but apparently you cannot ask a juror. So think about asking them what's going on in their life, and then you just say, does that feel stressful? Is it distracting you? Does your mind keep going back to that? Is it getting better or worse? Worse. Does it keep you from listening? And then you have the studies to back it up. So interviewing people about stress. Anxiety is different. Anxiety can be a chronic condition. Some of us have things we're anxious about. Health conditions of members of our family, young ones, elderly that we're concerned about. So we have an ongoing, what I call chronic anxiety, and explain it. And chronic anxiety impairs us completely. Jurors who are not able to do the job, get in your mind as a lawyer, the job is listening, remembering, and then being able to retrieve it later in terms of conversation. I have to listen, then I have to be able to remember it, it has to go in short-term memory, then it has to go into a long-term memory folder, long enough to wait for deliberations. If any of that is impaired, they are gone, and that is much more fun than you can't be fair to my guy. But we haven't been doing it. And all the brothers and sisters are doing it. I list at least 30 questions on stress with the studies that you can do there. I'm putting it on your table now as we do some other really fun stuff that starts helping us realize that voir dire can be great. Our key is always going to be making sure when I voir dire the jury that I am doing, in fact, dramatic, theatrical things that make my client not guilty. So, you've heard a lot today about primacy, recency, creating dramatic moments. First thing you say to the jurors is your dramatic moment. It cannot be. Thank you, Your Honor. May it please the court. Counsel, Mr. Martinez. First words out of your mouth. So I'll give you an example and ask you if this does not. Does anybody have a DA that you appear in front of regularly you don't like much? Like a... Okay, this is for that DA. So, do we go first or second? Second. This is a good thing. So, I promise you that going second, this will have happened. So, I was sitting there. I did not object during their voir dire. Judge turns to me, counsel. Do you care to inquire? And if you want to say, yes, we would, you can. You get up there in front of the jury. And it looks like this. It's been so hard for me to sit and wait because I listened to the prosecutor 3 times say something that it's against the law in the United States of America. Camera hold. What is our prosecutor doing right about now? But I know he is, so I'm going to put the spotlight on him intentionally, then need him to sit down. But perhaps he doesn't know he did that, and I'm worried it might impair you. So let me show what he did say that was against the law and ask what effect it had on you. Notice how I did. Now, do you want to know what it was? Yeah. And I promise you it will happen in every case. Here's the only caveat. Y'all have a tendency to do it yourself, so you got to stop doing it. But it's worth it. 3 times he told you. We just want jurors to have an open mind. We're looking for jurors with an open mind. Sir, could you keep an open mind? That is against the law in the United States of America for hundreds of years. Because when it comes to a criminal case, where you can be locked in jail whether or not you really did the crime, we have a higher standard. It's called presumed innocent. See, it's different. Let me ask you, sir, you can see what's causing me such concern. Because if a person's got an open mind, you're sitting there saying, maybe did it, maybe didn't. Don't know. I'm open. If you presume him innocent, you're sitting here saying, the charges are wrong, they got the wrong guy. Now, talk me out of it. See how it's real different? One phrase from a prosecutor saying, keep an open mind, says, we aren't going to follow the law in this court. I'm worried about the effect. Now, did we like this? Did I win one round? Do I care if he wants to approach the bench or not? I'm right. Open mind is against the law of the United States. Do I love opening with that? Yeah. Don't do it when you're for the first time when your prosecutor's a really sweet person that the jury already really loves because of whatever their charisma is. So one ever deserves to die. But wait, and then be sure that you've trained yourself out of ever saying it again. We'll never again say, keep an open mind. Could you keep an open mind? It is against the law. It drives me nuts when people let them say it. I have had to approach the bench with that when I finally pointed out to the judge that it would be kind of not the same as the presumption of innocence. And it scrambles everybody from the beginning. What does the jury get? Theater. This is why we came to watch. When she gets up, it's going to get good real fast. So they're heightened listening. And it's on a fairness issue, not having fun issue. It's on a fairness issue. Entertain on justice and fairness. So my theme is going to be consistently that. But does it have to be that every time? Well, no. Here's another one they do a lot. So we're just talking about voir dire as an opportunity to start the zealous advocacy. Zealous meaning the height of advocacy. They train you out of being zealous advocates because they don't like it. It takes too much time and nobody else does that. So, what happens? There is charges against your client. And they get to call themselves what? State or the people. People? You want to call themselves people now? Can I stop them from calling themselves people? I'm a realist here. No. Anything the other side does, like keep an open mind, that I know they're going to normally and naturally do, I'm going to make it hurt them. I'm not going to ask the judge for anything. I'm just going to make it hurt them. There was another thing, or if I want to make this my first thing, they kept saying something that's bothering me a lot because it ain't quite right. They called themselves the people of the state of Colorado, California, Timbuktu, have a right to a fair trial too, and the people of the state of Timbuktu believe and brought these charges. Let me just ask, because I'm getting concerned. Who got a phone call saying, should we charge this guy? Do we have enough? Do we even have the right guy? Did y'all get phone calls? And they will laugh. And you realize that maybe if they had called you, you'd have said, don't charge him, you got the wrong guy. This is fun voir dire. Because you're right on, you're saying, I can tell you that he can call his grandma. Because we asked, did you get the call? You know, so I'm making him a little more human. You didn't get the call. Is it possible, then, that using the name people of the state of Colorado, they might have charged the guy for something he didn't do at all? What do you think? So now you're back into the correct voir dire. But they keep using those words. It's making me think that you think that the people of this good state thinks it was a good idea to charged this exact minute. So, there you go. Dramatic moments. There's 1,000. Give me any case and we will talk about what your dramatic moment can be. But there's no way they can talk you out of those. They're just there. I want to give you some case specifics and some really good forms of questions. I'm trying to decide which order to start you with on this. Open-ended versus closed-ended, quick rule. Open-ended questions, tell me about your world. I'm getting connected with you. Closed-ended questions are for a tiny moment of teaching or leading you to challenge for cause. We'll do close first because it's really easy. I give you, no matter what answer a juror gives, we can lead them to a challenge for cause. I give you the 10 steps to lead any juror to challenge for cause in here, and you're welcome to copy it out. With the law on every step as to why you get to say it. But it means that once I've got an answer, what's a bad answer a juror gives? Give me a bad answer. Means they're not defense-oriented. They might say what?
They've been a victim of a crime.
Go what?
They've been a victim of a crime.
Yeah, that they've been a victim of a crime. So obviously I want to take them down. What is the ending destination for every challenge for cause in every state? I've got my doubts about whether that would affect me. Technically the language is I have serious doubts or some doubts or doubts I can't erase, but I got my doubts. So as soon as people say, and those doubts are important to you, yes they are. I got my doubts, just don't know whether that would affect me. Well, naturally that's a horrible thing. And so I'm leading them down. I'm telling you, because I'm not going to run through the challenge for cause, that those are all straight out. Of course, and that was painful. And you would understand better than anyone who hasn't been the victim what that felt like, why some things can be confusing but still true. And that's something you've been thinking about already, and we're going to go all the way through. Here's the good news on a challenge for cause. If they suddenly go off the path that we were traveling so happily together, let them go. They aren't going to go there, so it's okay, but I'm taking my chances. The learning point is closed-ended questions then. So you would testify if it was a trial for you, even though you know you don't have to, you'd testify. Of course, it's not even going to make sense to you that an innocent guy's going to sit there and say, no, I'm just going to sit here. That's looking a little screwball for you. So notice I'm in their world, stepping down that path with them. I mean, you're going to say, yeah, I know it can, but in your mind you're going, that didn't seem right. So I'm walking nice steps, and notice they're closed-ended. Open-ended questions say this. So you're thinking that you testify to the group. I want you to think of a reason that makes sense to you that an innocent man would choose not to testify. That's an open-ended question that asks for a reason. Give me a reason that makes sense to you that an innocent man wouldn't testify. You win either way. The good news is they might come up with a reason. Do not say, tell me a reason a guy wouldn't testify. They will tell you about prior felonies. An innocent person wouldn't testify. What happens if they cannot think of a reason an innocent person wouldn't testify? They're disqualified. They can't even think, of course, you can't even think of one now. It just doesn't make sense to you. Now we're down the challenge for cause. If a person cannot come up with a reason that makes sense to them that a person would not testify, they're gone. So notice, I open the question to find out. I'm ready for good news either way. The jurors are hearing from one another reasons innocent person could. By the way, the innocent person reasons tend to be he knows who did it and doesn't want to be the person to take him down. He knows who did it and loves them. You know, he's making the choice not to be a prosecutor, saying, I just don't think it'll fit me. And I can suggest those if nobody else does. But they're pretty good at coming up with those. So open-ended versus closed-ended, and I'm going to give you lots of examples of that. My favorite open-ended question. Has anybody, truth be told, has anybody ever announced ready on more than one trial on Monday?
Yeah.
7 or 8 sometimes? Come on. Defenders. Has anybody ever announced ready on a trial and you're still saying to yourself, tell the truth? I wonder what my defense is going to be. Maybe it's only a misdemeanor court, but you're kind of thinking, what is my defense going to be in this? I don't deal with who else is on the docket. This is the perfect question for you, besides that it's legitimate. So this is called, can you think of a reason? It goes straight to your case, your story. Can you think of a reason a cop would stop somebody who the cop says was weaving in and out of lines, and who the cop says he could smell alcohol on their breath, but it turns out the guy's 100% innocent of drinking and driving? And then you listen to the answer and go with that. Can you think of a reason? Hello? Can you think of a reason a 6-year-old girl would say her uncle touched her in places between her legs, and it turns out it never happened? And just wait for their answer and go with that. Because what happens if they say, I can't think of a reason a 6-year-old would say her uncle touched her between the legs if it didn't happen at all? You win, right? Because she's gone. So you can't even think of a reason. If you hear a 6-year-old girl says, this person who I know touched me between my legs, for you, that's it. You can't even think of a logical reason that makes sense to you. You've got them for cause. Got it? They are your friends no matter what. No matter how strange their worlds are, I am willing to go with them into their wonderful, strange worlds that will take them out of my courthouse. And I'm willing to accept it. As a matter of fact, you have some other trials set for next week, and you haven't quite figured out the defense. Ask about that one. By the way, you think of a reason a cop would say, and you go, yeah, an expert would run a test, and he says it smells solid. How about a reason DNA supposedly matches, but the guy's totally innocent? You have an answer to that? Just go with their accumulated reasons, because it is lay wisdom. It is folk wisdom about why things don't work. And you're going with those. The reasons people already have in their heads are the reasons that they will believe. Oh my God. Defendant's dilemma. There's 2 dilemmas defendants have, and I like bringing those out because they convict people. It's what I call sort of nonverbal conviction. One is the one you're aware of. If your client's not going to testify at trial, you're wondering how people are going to react to that. I can tell you how they react to that. They don't like it. They think he's guilty. And the truth is, they're probably right. So, it's not like they're out to lunch, but we don't want that to be the assumption. Voir dire is the only place to squash it. So, if you have a client that you know is not going to testify, which may be most of your clients, you set it up as a defendant's dilemma. There's a dilemma the defendant has and a decision he uniquely has to make later on, and I need to give him advice. If you already have an opinion on that, then that will affect who we select on the jury or how we will exercise that. He can choose to testify or he can choose not to at all, and there'll be nothing there. Now let's assume a guy who didn't do anything. Use those phrases as often as you can. A guy who didn't do anything says, I think I better testify. As some of you shared with us, it just seems like I ought to tell him that. And I say, but you told him not guilty. He goes, yeah, but what if one of them said, I testify? And y'all told us you're thinking that. So I go, but you don't have to say anything after you've said not guilty. If you're not the one, notice how I'm having a gestalt dialogue with my client in front of the jury. He's back there, but I'm giving them the dialogue. Well, suppose he testifies, and it's now a closing argument. The DA gets to get up and say, of course I don't know if they would, but he could if he wanted to say, well, folks, you heard from the defendant, a lot of other people. Who had the most to lose? Well, since we know he's going to say who had the most to lose, and we'll raise our hands. We do. That'd be us. We have the most to lose. You already know that the DA is going to say there's one person you have to discount completely. The guy who has the most to lose. On the other hand, if you sit there and you're thinking, oh my God, some one person's going to say, you should have gotten up there and say, I don't know anything about it, don't know any of these people, it wasn't me. But you said not guilty. So the law takes that dilemma away from you by saying we're going to give them an instruction that says don't look at that at all. You can sit there and they will be ordered not to pay any attention to it. And if even one of them brings it up, they have to send a note to the judge and say, somebody brought it up, what should we do now? Notice how we've used it in a logical way to have it make sense. The second dilemma that every defendant faces, you just may not notice because often they're behind us, is laughter in the courtroom. Somebody makes a joke, and it usually happens in voir dire. The judge makes a joke, the prosecutor makes a joke. What's the dilemma of the defendant when jokes are made in the courtroom? Yeah, because if I do laugh, everybody's going to laugh because he thinks this is all just a big joke. And people interpret the way you laugh bizarrely. On the other hand, if we're all kind of laughing, and he doesn't, and you're watching him, what might some juror think? And this is what I say to the jury. Yeah, or what a jerk, or what a weirdo. So he can't win, even though it's his life on the line and things may not be funny. Some man can hold open the possibility. If he doesn't laugh, it's just not funny to him. His mind and his heart are in a different place. That's how we end it back down and take it out. So we take those things away. There are some things in court that I need them to know real quickly, and that I want you to be able to tell them real quickly. Do I need to select something now? And that is going to give you more mistrials than anything else. So what do you have to trade? Will give you more mistrials than anything else? Chocolate? Love and adoration? You have to create a jury of 12 snitches. Remember I told you about misconduct? They always do it. You just don't find out till the end. They start doing misconduct the moment the trial starts. They start it before they're even sworn. They say things they shouldn't say. They express opinions they shouldn't. They watch the TV. To create a jury of 12 snitches, it has to happen in voir dire. Let's move this to the cutting edge, my brothers and sisters. It goes like this. By the way, there's a right you all have that nobody told you about. I want to ask you if you think you'd be able to exercise that right by law. Anytime you see something that bothers you, you need something, you overhear something you're not sure you should have overheard or you're pretty sure you shouldn't have, you should send a note to the judge. Let the judge figure it out. Would you trust her honor to be able to figure out what to do about it? Or are you going to say, I don't think I should tell anyone? Would you let them know? You heard something in an elevator, you heard something in a bathroom, a juror mentioned something. You're not going to say, but I like Mrs. Smith, don't want to get her in trouble. We aren't in 6th grade, folks. Just send out a note to the judge. When you do that voir dire, pretty much like that, you will have at least 10 notes a day. My last trial, which was a little while before grad school, we were getting 10 notes a day, such that the judge would come out before we started the trial that day with a pile of notes, and he'd start reading them on the record. Mrs. Smith would like to have a cutting of my spider plant. Brown wants to know if we can have a little refrigerator in the jury room. Mrs. Martinez wants you to know that juror number 7 isn't listening. First one that came out. Appellate lawyer's delight. I don't have it. I just want you to see the handwriting. I don't have it on a straight up, but I'm going to read it to you. Judge Meyer, 1. What is the criteria for a juror who's sequestered to be allowed to go home? They were sequestered. Number 2. This is where it gets good. Why is it that none of the minority jurors currently sequestered have been allowed to go home, and 2 white sequestered jurors have gone home? Oh my God! You have your trial. You have your appeal. She's snitching off the bailiff. The other jurors who were saying juror number 7 isn't listening, I'm going to say this really fast so I can give you a whole bunch of other questions. Once they know that if somebody's not listening, he was 80 years old and he was kind of nodding off and couldn't hear well. In the book I explain everything you need to know about the aging brain. And I don't care if you think it applies to you, and I don't care what drugs you may be on. I care if your jurors are on them. The aging brain loses short-term memory, loses hearing, loses all kinds of things that we need to have back on. In any event, you bring the juror in. Judge said, Mr. Jones, we understand you may have some trouble hearing. And I swear on the record reflects, he said, huh? The judge kept screaming at him and on and on. So you'll get that, but the only way you got it is because jurors know, 1, you have the duty to send out notes. 2, you never have to show your note to any other juror or tell them what was in it. And I'll tell you, this is what happens when notes go into chambers, and I set out the procedure in there, that after a juror comes in and we've talked with them, why do you think he's not hearing? Because he keeps saying to me, what is everybody saying? The last thing a judge says to a juror after listening to what they've snitched off before they go back to the jury room is what? By the way, you are instructed not to tell the other jurors what we said. I now am going into the jury room as a juror. What's the first thing the other jurors are going to say to this person? I can't tell you. Now, when this goes on, in the average incident for about 45 minutes or an hour, and several jurors are drawn out, and each one comes back saying, I can't tell you, you will get the following note, I promise you. Juror number 3 wants to know what the heck is going on. And that juror gets brought in, well, is that distracting you? What do you think is going on? Unless people told you what's going on. You know, make people's behaviors work in your favor. We're going to do a whole series of questions that comes from therapy, which nobody apparently wants to admit they've ever been in. It's called STEM questions. And STEM questions go through and start the question and then proceed a little further with it as we go through. So a STEM question says, one reason a police officer might lie, even though he's normally a good guy, is, notice I've started it and the juror finishes it. For me, I'd be concerned about believing a teenager who, it's non-antagonistic. A STEM question puts us on the same page. It allows you to say whatever you want. I'm not suggesting your answer, but it's not the pop quiz question answer. I don't think I could believe someone who, what really bothers me about somebody who has a prior felony would be, so that's a STEM question. You take the thing and then you finish it off. And the juror finishes it off for you. So now we're changing just a little bit the form of the question as we go through. Can you think of a reason question? Can you think of a reason consistent with innocence? Always. That a woman might only be able to escape with her life if she shot a man who was sleeping? Because after all, that is a bad fact. STEM questions. Here's the pop quiz on top. Why doesn't a defendant have to testify under the law? If, STEM question. For me, one reason an innocent person might choose not to testify is a whole list of STEM questions. I also have tons of these in this. If I'm a juror and hear something about another juror shouldn't have said to me, I think I would, after I told them about sending the notes, mention them up. If I notice a witness keeps fidgeting and pausing in their answers, that would mean to me, because you know the DA has a witness like that. I always do that because every witness looks to the DA during cross. If I know a witness is going to keep looking at the DA every time, that would mean to me. The kind of evidence that would show me insanity would have to include, so notice, for me, self-defense, I couldn't vote for it unless I'd hear. Notice I really do want to know their world. I'm not trying to lead them someplace, because it's key to me to know from you what you would need for self-defense. The most important part of cross-examination for me would be, I don't like it when police officers, I have no respect for lawyers who, it just goes on and on and on. A reason a child might lie about somebody could be, one law I'd like to change. If you're going to cross-examine a child, for me, you'd better, I could only vote not guilty if two experts disagreed, what would it be? The drug companies, who have a lot of money, started advertising in magazines because I'm interested in the biopsychology of people's brains. And I took 3 postdoc years in psychology, studying psychopharmacology for one, which is about as much fun as you can possibly have. There are 2 kinds of problems people can have mentally. They are either diagnosed or not diagnosed. If they're not diagnosed, you are self-medicating. That's most of us. I'm interested not in the illegal drugs jurors can be on, but in the over-the-counter drugs jurors are on. And so in the Summers book, this last fall, I list for you every single drug reasonably any juror could be taking, the condition it would be prescribed for, what it works on in your neural system, and what the manufacturers of the drugs say in their advertisement that are the results that will happen to a person taking that particular drug. So, for example, I don't think this is going to show, I've got a piece of white paper. That's okay, let me do a straight one. I'll do it, no, I'll just do a straight one. That doesn't have. I don't know if you can hear this. Abilify you take for bipolar disorder. Now, God bless all of us who are bipolar, but you don't want a juror who's bipolar and taking meds, because meds for bipolar give you a flattened emotional affect. You don't get your normal emotional reactions to things. Ambien and all the rest. These aren't going to come out good, so I'm going to read them off real quick. Do you know why a person takes Aricept? Here's the question on a questionnaire. Tell us what drugs and medication you're taking. That's it. Don't ask them why. Don't ask them the conditions, how much, or what effect. Just get them to list the drugs. You don't need a PDR. You go straight to the thing. You've got little tear-outs. And we go, Aricept. I promise you, you've had jurors that are on Aricept because nobody tells the patient why they're taking it. Aricept is given to somebody who has Alzheimer's. Alzheimer's people get called for jury duty all the time, and in early Alzheimer's, they're looking for stuff to do. Sounds good. If a judge doesn't excuse a juror on Aricept, you have such a free trial. Ambien. You're thinking, remember Patrick Kennedy or whoever was on Ambien and drove his car in the middle of the night and freaked out? All of the Nestra has a little butterfly on, having trouble sleeping because everybody's overworked, distracted, and stressed out. They're on these drugs. Here's what Ambien gives you if you took it the night before, which if you're trying to hold down your job and do jury duty, you probably would. The next day, you should expect to feel drowsy, dizzy, sleepy. You should have a headache. You will probably be at risk for dependency, according to the manufacturer. I'm quoting. Do we love it already? Ambien will also result in memory problems, with a memory loss, and withdrawal symptoms if you suddenly stop taking it. Now you can say, who's been taking it? Don't suddenly stop. Changes in behavior may also include changes in bizarre thinking, confusion, agitation, hallucinations, and suicidal thoughts. All we ever had to do was ask what drugs they're on, prescription and over-the-counter, and you can grind your trial to a halt. You win either way. You're getting these jurors out, you're learning about their lives and that they're stressed, about which you can show compassion. No judge can get around it. This is a manufacturer's statement, and I show you how to just take the tear-outs from the ads, mark them into evidence. You know, all of these things are amazing, and every single one of those drugs has an effect that would be reversible error if we didn't do something about it. I should do this real quick so I'll get in. I have put everybody's name in here, because I want to give my yellow book away. This is wonderful. I want you to have the ammunition. I know you'll share, and they don't give me boxes of books as we go through. So have all your names in. That's one is the hard part. You have to be present to win. Candace Chambers. So she'll let you copy all the questions. Pull questions for specific situations. We're going to go through a whole bunch and stop and think. I know all the horrible things that we have that begin to happen. Here's what happens. It's not a juror's opinion that matters so much as the strength of the opinion. So if you're saying you think cops lie, for example, it's how strongly someone believes it. You know, some of us like chocolate. Some of us are passionate. It's how strong. So the form of these questions on key case issues goes, do you feel police officers lie, for example? Well, yes, I think you do. Well, how strongly do you feel about that? Let me give you some choices. Extremely strongly, very strongly, somewhat strongly, not at all. So that could go on a questionnaire. Or I could say, if the scale is 7, I really strongly, it happens way often than any of us know, versus, well, I think it could happen, but really hardly ever. And that's a 1. Where do you stand on cops lying? On kids not telling the truth, on experts always being right, on DNA. Notice I pick something critical to my case, get an opinion, and then measure the strength of it, allowing them to tell me verbally where they stand on that, what is going on. Using jurors back and forth. Nobody wants to hear from you. You are suspect. You have a known bias. So if somebody says, I think a defendant, which is an easy one to practice tomorrow, really ought to testify, even though I know it doesn't have to, I'll follow it along, I'm not going to let it, but I'd sure testify. And he's saying that I think he should. Does anybody feel differently? Now, what are you thinking? So now I summarize her. So she's saying there's a whole lot of reasons that an innocent person might feel that it wouldn't do any good. Everybody's going to say don't believe them anyway. What do you say to her? And I let them go back and forth. Anybody have an opinion? Where do you fall on that? And you can let them talk. It's called take it and spread it. Do you agree? Can you think of an exception? Can you think of another reason? And they say it, not me. Mistaken identity cases. Never use the following. You ever walk down the street, saw somebody and go, yo, Bo! Turns around, he's not there. Why is that a terrible example? When you got closer, did you finally figure out it wasn't Bo? Is that what's going to happen in court? The person's going to get up to him and go, oh, now I realize you're not the one. They're still firmly believing. So these are not parallel examples. We do not use ordinary, itsy-bitsy, trivial things for things in court that are life-threatening. You don't say, have you ever been accused of something you didn't do? Could you give us an example? Well, I was in second grade, and they said I took her pencil box. And you go, see, isn't that a perfect example? I don't know, not unless you've been accused of rape. It's not the same thing. So we're trying to use things that are really vividly there for the jurors instead of examples that are way off the wall. How many people have to go to trial when there's a whole lot of evidence against your client? Okay. Don't tell them about a recipe. And if you leave out the oregano, it's spaghetti. Don't tell them about, do you ever leave the house and not sure if you left the iron on? Don't tell them about how much reasonable doubt would you want to buy a house, because none of those are parallel examples to a lot of evidence in a criminal case. Quick example, you can come up with better ones. So this is the way I would perform the voir dire, assuming that I'm talking to a parent. Anybody here ever watch any of those murder mystery shows where somebody's going to get murdered, we're going to see it in the first scene, and we know, and then the rest of the case is trying to figure it out. And now, you can name Gary Mason, you can name MCIS, anything, but the murder happens. Okay, so they're into it. You ever see one of those that actually starts something like this? In the first scene, what happens is we see the real guy shoot somebody and drop the gun and run away. Then our hero walks in, sees the dead body and the gun, and what does he do? He picks up the gun. So we got our hero with the gun in his hand, standing over the dead body. Let's make the case even stronger. Say the night before, in front of a room full of nuns and priests, he said, you bastard, I'll kill you. And he has a real good motive for what he did. What do you know for sure with all that evidence? The jury convicts him. They convicted an innocent man. So is it possible for you, ma'am, that there could be a lot of evidence against somebody and they did not do it? So the evidence has to erase every reasonable doubt. Having evidence doesn't make the case effective. So I'm giving a parallel example, not spaghetti and buying a house or anything like that. A parallel example that really ups the ante as we go through there. In terms of mistake and people being wrong, it's not that little see somebody on the street and they go through, because what's going to happen is not like that at all. Some of us can't afford experts. Some of us who have had clients that could afford them have a lot of clients that couldn't. One voir dire tool is studies have shown. I like it because I know about all the studies, but I give you a lot of studies that I write about so you can use them too. Studies have shown that most people who are certain about an identification don't realize the factors that might make them completely wrong. What do you think? You ever read a study, you disagree with it, you agree with it? That makes it a valid voir dire question. I never have to call a witness. It's a legitimate voir dire question if it might affect you, if you already have an opinion on that. Studies have shown that before a child is 12 years old, they have not enough neural pathways to discern quickly and easily fantasy versus reality in the hard science way. Older children can do that. What do you think about that? What is your experience with that? Here's the umbrella that will protect you from all forms of objection during voir dire. I'm an appellate attorney now giving you advice so that we get it right. People will object to voir dire when they see it's effective or just different. Doesn't mean you are wrong. But I prefer not to be objected to. So this is a prophylactic, so you can practice safe voir dire. Prophylactic means I want the judge to hear why this is a legitimate voir dire question, so we don't all have to guess. I'm going to ask you something that might affect your verdict in this case, even though it's not law and it's not evidence. Since your verdict is supposed to be based on law and evidence, if this thing would affect you, we have a right to know about it. The thing is, and then I go into my thing. I'm going to ask you about something that might end up affecting you, an experience you might have had that might affect you, even though it's not going to be law in this case and it's not going to be evidence. That is your prophylactic. It tells the judge you've got a reason for it, it's a legitimate reason, you have a right to ask about it. For anything, whatever it is I'm going to ask about, because it's an issue in my case. And I'm alerting the jurors as well, so they understand it. Studies have shown that the certainty with which an eyewitness says they're sure has nothing to do with the accuracy of the identification. The person's own level of certainty has nothing to do with whether the thing is accurate. True or not true for you? What are your experiences? It could affect you. If you believe that's true or it's not true, we would have a right to know that. So much better stuff. Studies have shown that stress of an eyewitness decreases accuracy, even though many of us think, gee, if you're really under stress, you pay a lot of attention and be more accurate. Turns out our brain is worried about fleeing and surviving, so it takes a lot of the blood away from our memory retrieval. What do you think? What are your ideas about that? So you're able to voir dire on the case. One of the most important things that happens in your voir dire is early on, with the theater, with the primacy, they know within moments what my defense is. We aren't waiting around, not asking about guns and kids and hobbies and magazines. Out of my lips early on says, this is a case. This is my parentheses. The law says you're allowed to voir dire on anything that's an issue in the case. The law says you're allowed to voir dire on anything that's an issue in the case. So here's your voir dire. This is a case in which a man who was somewhere else at the time has been charged with robbery, and the issue before you will be whether he was in a bank robbing it or someplace completely different at the time. The law says that if you have a fear of death or serious harm to somebody else, you can use deadly force. The issue here is whether or not that's exactly what happened. The law says that even if a witness is sure, the juror decides if the identification matches. The issue for you will be whether this eyewitness is wrong or there are doubts about it. So whatever it is, they've got to know up front what your defense is, and you've got to get it out there for them early so they aren't wondering why you're asking all these questions. I worry about, I'm concerned about, is me disclosing these things to the jurors. On law, real quick, I don't want to leave that out. Anybody try to voir dire on reasonable doubt, presumption of innocence? Does that feel good? A touchy-feely moment? Using primacy, using attention-getting words, and voir diring in a way that they will get it on reasonable doubt. So this is what this does. Here's how it sounds. You know, there's three things about the law and reasonable doubt no one has told you. So listen up then. You have a right to know. One, there's no size requirement for reasonable doubt. For one of you, it might be huge. They'd have to drive a truck through. For someone else, it might be small. But it is a reasonable doubt. There's no size requirement. Number two, isn't that true? Am I right? Okay. Number two, the jurors don't have to agree on what the reasonable doubt was. You know, jurors sit there thinking they have to agree that it was the height or agree that it was the test. They think they have to agree on the reasonable. One juror, and this is the way I say it to them, can have a real problem with the way the tests were run, that the protocol wasn't followed. Another juror can say, you know, the description doesn't match. That bothers me. that really bothers me. And you never have to take on the burden of getting another juror to agree as to what your reasonable doubt was, ever. It just doesn't have to be there. And finally, although a case may be full of reasonable doubts in terms of motive, actual things that match or things that look at somebody else or whether tests were done correctly, a case only needs one reasonable doubt to fail. And that's a burden they have from the day they get the case and they know it. So notice how I set it up as three things that is solving a problem for them as opposed to redefining it or doing it. They can't stop me from doing that in terms of what's going on. Just absolutely. Let me give you this one, which is trying to encourage you to have a little law in your briefcase when you go to the court. And have a little drama with the DA. Is it not wonderful to be able to say the following to a DA? Again, imagine my hypothetical DA. Some of you have a DA you don't like much who deserves this. Reasonable doubt in these United States of America means, do y'all have achy reasonable doubt instructions? Y'all try and explain them. Notice how simple I'm going to make it. Reasonable doubt in these United States of America means, and I might say to him when I'm saying that this will make my day, because he knows. Charming Jeff, because I'm ready. Utmost certainty. Don't we like that one? And you're going to say, but that's not our instruction. But it's a constitutional definition. Now, if I say reasonable doubt means utmost certainty, tell me what your DA is going to do. Yeah, so I can't stop that one. Matter of fact, that's why I'm begging him. When you want to, you know you can't stop him. You go, oh, come on, make my day. Clint Eastwood. Come on, your turn. Go. So he objects, and what am I going to say in front of the jury? Judge, that's what the Supreme Court said. May we approach so I can show you that case? It is what the Supreme Court said, and they were called upon to define what reasonable doubt actually meant. And why I know it's because I had to do some appellate work on another case. This is such a good case that even when you say the name, the judge will know the case. Just put it in your book. In Re Winship, the case that applied reasonable doubt to juveniles. In Re, I-N-R-E, that's how we do juvenile cases, Winship, W-I-N-S-H-I-P. And in it, they really defined. It's the case, you'll love it for another reason, that said it's better that 10 guilty men go free than a single innocent person serve a day for something he did not do. It's kind of nice to have for that, too. But it means I got reasonably. What are the jurors here? This is called, we don't want to do credibility, believability. She has law to back up her stuff. And she goes to the guts of the case when she does it. I have 1,000 things, so I'm going to do two things. I made for you the best demographic questionnaire to show you what a jury questionnaire on demographics should look like. And I'm happy to talk with you all as it goes through. Instead of education or any of the rest, here's what you really need. I made for you a jury sheet, which tells you how to organize the information you get about your jurors as it goes through. And now, I'm going to tell you that the newest, hottest thing is recognizing the powerful way a juror's religion affects a jury. And this one in order. I want you to, instead of asking what is your religion, a juror's religion always impacts them. Notice I have it set up as 5 questions I need to know. Because it's not your current religion, it's the history. What is the religion of each of your parents? You know, Dad's Pentecostal and Mom was Southern Baptist. That's a story right there. You know, you need to know parents because they were with their parents for maybe 20 years. And they're only 25. That's a big part of their religious background. It's their default, their early imprinting. The religion you currently most closely identify with. Why do I say it that way? Because a person's going to say, I'm spiritual, not religious. It'll get me more people choosing something. Well, I'm kind of, kind of a Methodist, kind of Unitarian, whatever I am. Kind of Jewish Zen, popular one. Past religions you have identified with. Oh my God, who cares if they are today if they used to be this other thing that's pretty powerful? The religion of your husband or wife, that's the one I'd dump if I had to dump one. But I'm kind of a curious gal, so why not? The most important down there for prediction, religion you're currently raising your children in, because that's a behavior. I study and teach persuasion. You want to predict a juror's behavior, not just their attitudes. A decision to raise your children in a religion is a more powerful predictor of how it is. Religion affects how they see science. You know that's true. Belief in evolution. Whether or not scientists are all playing games or really have some important information. Whether the Ten Commandments should be in the courthouse or not. Whether a president's religion is important or not. This has every case. If you have a case in which there's adultery or sexuality, isn't that everything? There are drugs or drug-getting cokes. Their religion will tell them something about it. If I'm a woman arguing to people, or in the Mormon church who put some restrictions on that, or a traditional Catholic priest who thinks that I shouldn't be a priest ever, or whatever it is, my gender is going to have an impact. That is important. If I only got a one-page questionnaire, I would put it on. And there is a case currently just out that gives you the right to ask that. Because I know, I can read your mind. Somebody's saying you can't do that in my jurisdiction. There's a case that says you can't. As a matter of fact, the book most often brought into the jury room turns out to be the Bible. And how Jesus gets into the jury room right away. The only question for us as we play with these is going to be not, I can't do it in my jurisdiction, but okay, that sounds a little different. You heard me out here. Tell me how I can make that work for me. That's all we're going to do this week. Tell me how I can make that work for me. And I'll leave you with the most powerful story I know about Voir, true life, and the most powerful faculty member we ever had here, Pat Bennett, my muse who taught us all what communication with jurors is. Anybody here have a bell ringing in your mind if I say Wounded Knee? You got some connections and reactions to that? And we have the original Wounded Knee, where many Native Americans were just slaughtered by our military forces back in the 1800s. But then in the 1970s, some of us remember we had the American Indian movement, we had a Black Power movement coming out, and leaders in the American Indian movement said, you know, we ought to think about our identity. We are tribal, indigenous groups, but we could come together, you know, whether you are Lakota or Hopi or whatever you are. Let's go take a stand at Wounded Knee, that place of infamy. Reclaim that land and just be present. This wasn't long after we had Kent State happen. And so the word went out to all tribes, come to Wounded Knee at this time and be counted as American Indian. Well, the government heard about this happening and they sent federal troops just in case. And I'll cut out the part of the story that is the most interesting, but guns were fired and people died at Wounded Knee. The guns that were fired came from the federal troops. The people who died were Native Americans. And using the kind of false belief system that results in felony murder rule, they charged Native Americans with murder under the federal rules, saying that you created a situation in which you knew that that was a likely outcome. And here's the sad part. They could get no one to defend them. That's back when everything was court appointed. And so the judge would call up somebody and say, would you take this appointment? It was in the Dakotas, and would you take this appointment? And the person would say, well, you know, I do criminal appointments, but, you know, I'm married. This would be real awkward for my wife if I represented one of the Indians. You know, I just can't really do it. And they call somebody else and say, well, my wife and I, we can handle that. We're mature, but I got kids. And, you know, they'd have to go to school, and their daddy represent one of them Indians. And somebody else would say, well, I could take it, but... Yeah. The Native Americans, but here is the deal. I'm not very good. You don't want me. They deserve better. So the word went out in what was a very small group of criminal defense attorneys that became our big organization. And they all came out to represent them for free. We didn't take a penny for the representation. Kat Bennett was there. She had just graduated with a master's in humanistic psychology and said, let me try to help you pick a jury. I hadn't really done that. And they started the jury the way they always do. And here's what happens. They brought the people in and did the bias first. Hundreds of people. They said, what is your opinion about the Native American people? People come in and say, well, hire one. And, maybe they'll show up, maybe they won't, but I could set it aside. Somebody else will say, well, I guess Native American people are okay, but get them around liquor, God, what's that? Somebody else will say, but I could set that aside. They're always on welfare, and hey, how about that Indian time? Maybe they'll be on the job, maybe they'll be on Indian time, who knows? It was just awful. Every day the prejudice against the Native Americans was huge. And then on the third day, a strange thing happened. A housewife came to the stand and sat down. She was asked the same preliminary prejudice question. What are your feelings about the Native American people? And she looked out at the courtroom and all of those defendants, and she said, my papa taught us we're all the same. That's what I believe. We're equal. And they all turned to Kat, all of the people defending the Native Americans, and said, well, we finally got somebody who can use us. And she shook her head. And she said, ask her this. It was before postage. She wrote down a single question. The attorney who took that question told me he almost couldn't get it out. It was so brilliant and so simple when it comes to racial prejudice. And he took it up, looked at the woman who was doing the voir dire for the group, and said, ma'am, can you give us an example? It's a brilliant question. Can you give me an example? And the woman thought, and she said, yes. Here's my example of my beliefs. When I was very young, I was about 6 years old on our ranch up in the Dakotas. We're sitting out in the front porch one day in the winter, and it was fixing to snow, and the sun was going down. My papa and I were sitting out there looking, and my dad pointed, and he could see some of those Indian families walking across. We could tell they had little ones with them. And my papa, the kind of guy he was, he started walking way out there to those folks. And he told them, I don't know where you're going or you've got plans, but it's getting cold and you've got little ones with you. If you'd like you have the use of our barn, bring you blankets and food, just kind of worried about you if you'd like it. She smiled, so proud of her papa. The attorneys turned to Kat and said, thank you, now we know what she counts for. Kat shook her head and said, no. Ask her this. And she wrote the second most powerful question you'll ever ask in a race case. And the attorney walked up with it and was embarrassed to even say it, and looked at the woman and said, can you tell us what your family would have done if those folks had been white? And the woman burst into tears. She started weeping there in the courtroom, and they all let her break it. And finally, when she could gather herself, she said, I'm sorry, I am so ashamed and I am so embarrassed because I can tell you this. I was raised to think I was not prejudiced or biased. I believed it with all my heart. And here's what I know now as you ask me that question. If those folks had been white, we'd have invited them into our house. And the attorney went back to Kat, and they turned to her and said, thank you so much. We will excuse her. Kat, no, we keep her. She knows who she is. That's it. So our job on voir dire is to step into their worlds and allow them to discover who they are as we do, and not to force it down with all of the open-ended and closed-ended questions we can. We'll be working on hypotheticals tomorrow, but I want to tell you tonight that I'm at your service. I will give you voir dire questions for any client you have, any client you anticipate having. Bring it. Let me give you the voir dire questions that might change the way you talk to people in the real cases you have, in the real clients you want to tell, and the real judges you anticipate objecting to. Come up to the table and we'll make that happen. And if I've got any resources or voir dire or anything you want